Judgment in the appeal, Gisda Cyf against Barratt.
The judgment of the court will be delivered by Lord Kerr.
This appeal concerns the question of how the effective date of termination of employment is to be determined. This question is important for a number of reasons. Those include the marking of the start of the 3-month period within which proceedings for unfair dismissal may be taken. In the present appeal, the relevant provision is Section 97, subsection 1 of the Employment Rights Act 1996. It defines the effective date of termination as the date on which the termination takes effect. The respondent, Lord Barratt, was the subject of a disciplinary hearing held on the 28th of November 2006. At the end of the hearing, she was told that she could expect to receive a letter on the 30th of November informing her of the outcome. She left home at 8 a.m. on the 30th of November, however, before any letter arrived. She went to London to see and help her sister, who had given birth a week earlier. The letter arrived later on the 30th of November, but Ms. Barratt did not read this until the morning of Monday, the 4th of December, and the reasons for this are explained in the judgment. Ms. Barratt made a claim for unfair dismissal and sex discrimination on the 2nd of March 2007, and depending on what view one takes of the date on which her employment was brought to an effective end, her claim was lodged either just within or just outside the period of 3 months from that date. If outside the period, Ms. Barratt would be unable to maintain her claim to have been unfairly dismissed. The Employment Tribunal held that the unfair dismissal claim was made in time. The decision was upheld on appeal by the Employment Appeal Tribunal and also on a further appeal by the Court of Appeal, and Gisda Cyf appealed to the Supreme Court. This court unanimously dismisses the appeal. We have decided that the effective date of the termination of employment is when the employee is informed of the dismissal or when she has had a reasonable opportunity of discovering that she has been dismissed. We have also decided that it is right to take into account the behaviour of the employee in assessing whether the employee has had a reasonable opportunity to find out about the dismissal. Again, the reasons for these conclusions are explained in the judgment. In short summary, we concluded that Section 97 is intended to hold the balance between employer and employee, but it does not require that both sides be placed on an equal footing. The section is part of a charter protecting employees' rights, which recognises that employees as a class are in a more vulnerable position than employers. An interpretation that promotes those rights is required to give effect to the purpose of the section. It would not be reasonable for time to begin to run against an employee in relation to his unfair dismissal complaint until the employee knows, or at least has a reasonable chance to find out, that he or she has been dismissed. On the question of whether it was right to take the behaviour of an employee into account in deciding whether he or she had a reasonable opportunity to find out about the dismissal, the court has concluded that it was necessary to be mindful of the human dimension in deciding what is reasonable to expect of someone facing the prospect of dismissal from employment. What is practically and objectively feasible may differ from what can realistically be expected.
The court will now adjourn.